Julio, will you please? So we are live again on Friday, March 17th, with Senate Economic Development, back on S-103 for now. David is coming back with an amendment to S-30. We'll take that up really quickly when he comes in. Yeah.
Okay, so we should get, I don't want to jinx it, but there's only one more change to look at. I can't say how quickly we'll get through it. So let me share that screen. Okay, so this is with respect to the comparable employer language.
What page are you?
This is, I'm sorry, page 4, lines 5 through 8. So previously, this language had said an employee shall not be required to demonstrate the existence of another employee or individual to whom the employee's treatment can be compared. So basically, what's often called a comparator. Unfortunately, when you think about equal pay, you have to have someone to compare to, because you can't have an equal pay claim if you're not looking at the pay of others. So this says, except for claims alleging a violation of subdivision A7, which is the equal pay subdivision, an employee shall not be required to demonstrate the existence of another individual or employee.
So we're kind of in between the don't darken my door and equal pay provision now.
Yeah, the don't darken my door was the subsection before, and there were no changes requested to that. So
right.
I just didn't touch on that.
I
so
just want to, yeah. So we're revisiting a clarification on equal pay, but it kind of comes in the same section as don't darken my door. So I just want to note that for people, so we can.
Yeah, and we can touch base on don't darken my door if you'd like to go there next. But are there questions on that change? Okay.
That
So
makes sense, everybody. Okay.
Yeah, so seeing no questions, the prior subsection is the what's called the don't darken my door subsection. So that goes from the bottom of page 3 to the top of page 4. And it basically says that an agreement to settle a claim.
Sorry.
Making sure you guys are all set. You need to email the document to you all.
With those changes, do people feel like they need anything else from David? Okay, we'll get through this section.
Lots, but not that you can deal with today.
Just let me
Hopefully
know.
we don't need you, but we'll,
Let me
yeah,
know.
thank you. So we'll, okay. Oh, okay. And we can just put, are people okay just pulling it up after we get through this section? We'll pull that up and vote. Okay, thanks, Steve.
No worries. So this basically, we added a similar provision for sexual harassment claims several years ago when we updated the sexual harassment law. This would extend it to all forms of employment discrimination and settlements of those employment discrimination claims. So it basically says you can't have a provision in there that prohibits the employee from working for the employer or a subsidiary of the employer or the employer's parent company or any of its affiliates in the future. So are there questions on that?
Questions, or I will say, Senator Clarkson, you asked for language from one of our witnesses about like a halfway point. I did forward that to you in case you wanted to somehow amend this section to put a time frame around.
I don't recall that discussion. This embeds,
For within 5, for at least 5 years.
that wasn't me.
Oh, I think that I said something.
Wendy.
Oh, I thought I remember you saying, are you suggesting something halfway? And he said there's not really a good halfway point.
No, I don't think that was me.
Oh, okay.
I think this, it means they can't put a time frame on it, and
You
And
just can't have the provision, period.
you can't have the provision,
Right.
period, in
Yeah.
the settlement agreement.
That's right. And this is separate from a non-compete,
Right.
from a non-disclosure,
Right. Yeah.
But you cannot-
non-disparagement.
I just wanted to be
Sure.
transparent that someone asked a witness if it was something like, this is the time to suggest language, or hold your peace or whatever. So he did, and I just want to note that for transparency's sake. I'm fine with the section as is, but I wanted to
Me
note
too.
that.
I'm fine with it too.
Okay. Okay.
And yeah, I think it was I who
Okay.
asked that of the attorney
Yeah.
and,
Of Rich Cassidy.
yes, and just said, for example, a 5-year, but.
Right.
There was lots of subsequent testimony and I'm fine with the language the
Okay.
way it is.
Okay. Does anyone want to raise any issues, clarifying questions before we assume people are either okay with this or going to vote no on the bill?
Just regarding this section.
Yeah, is there anything? Okay.
So
Oh, I think that, sorry, just to go,
Yeah.
my notes said there was discussion about whether it's prospective or goes back in time. We had
it
that
is,
conversation.
yes.
This, everything is prospective.
everything is prospective.
You can't really nullify it.
Yeah,
So,
right.
yeah,
As much as-
the, yeah, there are two different things that work against that. One is the statute, 1 VSA 214 says that our statutes are presumed to be prospective unless we notwithstand 1 VSA 214. And the second, which Julio mentioned yesterday, is the contracts clause of the US Constitution,
Mhm.
which prohibits us from impairing the function of contracts. There's a balancing test that's involved whenever a state does that.
Right.
So for example, if we raise the minimum wage, prospectively, you have to pay people under that. And we would, and there's a balancing test for that, but we're not voiding previous contracts. Here, this is basically saying, going forward, when you settle a case, you can't have this in the contract anymore. If someone has this already, we're not addressing those contracts. That would be another piece in here, and we'd have to start talking about the constitutional issue. We'd have to add language notwithstanding the statute that provides that we don't do that and so forth. So I think that would be a much bigger issue if
Okay.
that's something the committee wanted to consider.
Nope, I feel
So-
bad if a witness like feels like he was asked to do something.
So, there are probably a few cases in progress. So does the case,
If they
if
settle
something's
it,
in progress and this takes
so
effect,
if this takes effect and the case is in progress and they enter into that settlement agreement after July 1, that settlement agreement has to comply with the law.
okay,
So that's
which will be new.
That's your
then.
cutoff date.
Okay.
So you may see the parties rushing to settle. Or you may see them saying, fine, okay, we'll negotiate around that issue. And that's going to be up to the parties to decide. Anytime we change the playing field and there's an effective date, you may see parties racing to get something done before the law changes because the prior law favors what they want more than the new law, or
Okay.
vice versa. You may see parties delaying too, because we can take advantage of the new law on July 1.
Okay,
So,
thank you.
So we're good on section on do not turn my door. Then let's pause. Did you get my email? Okay, great. So we have the amendment to S30.
That's for you.
We're gonna do more on 103.
Yes, yeah, we're going to go back to severe pervasive.
You said.
I'd like to just
I just
get the
I didn't
vote.
see it.
Do you want us to look at it on our computers? Or,
I'm
He's
gonna-
gonna pull it.
oh, good, okay.
Okay, so we're back on S30, I think very briefly, I hope it's very briefly, to vote to adopt. This amendment. Okay, so the two members is no longer highlighted because we have reviewed on paper, but the new change should be a per diem section toward the bottom, I guess. There it is. Okay.
Good.
Anything, if you scroll down a bit more, Scott, is that it? Okay, great. So it's all fit on one page. That's the change we're looking at.
And I'm fine with that. I think the only thing is that people may raise the the amount of
Yes.
meetings.
Right, the upper
As a-
range.
As a limitation that you want to have.
But I think David's point is a good one, which is for ongoing boards that are set up. There usually aren't set meetings. They are ongoing boards that are expected to go into the future.
Well, you normally set, I thought, a limit though on the number of meetings per year, so that if you don't get, you know, unintended amounts of compensation when they meet weekly.
We have a lot to do, so
Yeah.
I just ask that
but
we
how
can
can
tell
you-
appropriate, like anyone can go to appropriation. If they ask me about this, I'll say, you know, one thing that came up that we didn't get a chance to look at was if you want to set. Yeah. So I would entertain a motion so we can get back to our two big bills in the next hour.
I'm happy to move draft 3.1 of S30 that this committee vote it out favorably. Our sister state, and we look forward to many productive sister state
Let me
relationships.
just ask one other complicating question. Is there any envisionment, and I'm just trying to remember who the other members of the committee are, that any state employees other than legislators might be on this committee?
Oh, yeah, there are.
There
As the
appoint-
secretary.
Well,
ACCD.
you wouldn't pay $50 a day to someone who's a state employee.
No, they're already paid.
No,
Because
but
they're already being paid, and
Yes.
I'm just wondering if the language contemplates that.
this belts and suspenders language exists in every time we.
Yeah, but is there anything that we do
Yeah.
differently where there are members of the administration who are parts of committees?
It is all, we don't have David, and I will say these are all pursuant to, I mean, Damien might know this as well, like, if we want a lawyer's opinion, these are, this is belts and suspenders across the board where anyone pursuant to those sections of statute is offered compensation, but
Yeah,
it's understood that.
yeah, so the way this works is under 32 VSA 1010. That's for members of committees who are not compensated by the state.
Right.
And 2 VSA
Taken in
23
two.
is legislators. And then we always have to designate where the money is coming from. But if I pull up 32 VSA 1010.
I don't think we have time to do
I
that.
wouldn't worry about it.
So
But
if
yeah,
that could, you could withhold your positive vote on that, but I think this is exactly what we put in everything that doesn't compensate state employees.
That's the exception, is if you're paid full time, you aren't paid. That under number 2.
32 VSA 1010.
yep. So that provides, except for those members serving ex officio or otherwise regularly employed by the state, the members of board shall be entitled to per diem. Yeah,
So we have a motion to amend S30 with amendment 3.1. So we need to start with that vote.
Okay,
We can, amendments, we could just, all those in favor, please say aye.
I,
Aye.
Okay, so that's 5-0, and now we'll take a roll call vote on the bill.
okay, so just draft number 3.1.
Of S30.
Of S30, sorry. Senator Brock,
Yes,
Senator Clarkson,
Yes.
Senator Cummings,
Yes.
Senator Harrison, yes, Senator Romnick.
Yes,
Great, so it is 5-0,
great.
and the reporter,
Who wants to report this?
Do you want to do this with all your Japanese connections?
No, I have enough coming out of finance.
I know, I always look down in finance, so it's fair for Senator Cummings to go in here. So that means people are gonna get two.
Right, what, you want to do it?
this one seems
You want to do
not
this?
complicated,
Yeah,
so.
and you had your, okay, great. So, so we have 55 minutes, which is a healthy amount of time, I think, to get through the last section of 103 and then get through 102. But I will be watching the clock. I think 10 minutes on the last section of 103, I hope is sufficient for people to get their questions answered and decide where they stand on the severe or pervasive change.
So those are the only changes in the amendment. Are
Right.
there questions on specific sections, or do you want me to just briefly remind you what each section does
of 103.
of 103?
Is there another amendment other than 2.2?
So, and the other,
But we can,
Well, one question I have,
Yeah.
is on page 7,
mhm,
line 9. This is regarding things that you can't discriminate against, and one of them is because a person is a recipient of public assistance.
so this
if
is
you-
fair housing and this is existing law. I just
Yeah,
want to know
yeah.
that.
Well, it's listed as underlined, so I assume there's some correction. I don't know where it is in
the-
the paragraph.
the change is actually, this is existing law that was moved from last year. We had it in just the fair housing law because the severe or pervasive standard,
Mhm.
this bill would also remove that standard from public accommodations law. We can now put this definition into the definition for the whole subchapter or whole chapter of law rather than just in that section saying for purposes of this section only.
Here, I'm just looking at, I just have really a question on the issue because a person is a recipient of public assistance, that a landlord makes a determination of whether or not to rent a property based on the financial ability of the individual to pay for it. Now, if the individual is solely a recipient of public assistance and the landlord is renting it at X number of dollars a month and does not believe that that is sufficient to cover the rental and living expense and so on, it becomes a risk to
I'll just-
that be taken into
I'll
account.
let this question be answered, but I don't want to go into fair housing because we passed this last year and I don't want to run out of time on things that people want to discuss that's related to the changes we're making to law. This is something existing that we already passed
Right, so my understanding is that the state doesn't set the
last year.
rental rate for
Yes.
your unit. So as a landlord,
Right.
you're free to charge whatever rate you want. What this is covering though, is if someone can afford your unit with a Section 8 voucher, for example, you can't simply say, oh, you've got a Section 8 voucher, I'm not gonna rent to you, I wanna rent to someone who's not on a voucher. So, and that's assuming they can afford the unit.
Well, that's assuming. they
With
can-
their voucher.
all right, That's what I want to, that's what
Yeah.
I want to have an understanding is it would not disqualify the landlord for the ability to say that voucher will not cover the cost of the rental that I'm renting it for, and therefore
Right, the individual has to be able to pay the rental amount. And so if they can't cover it with their voucher, they need to cover it some other way.
Okay.
And the landlord still has the, abilities that they have. The abilities that they have already to say the rental for this unit is, whatever it is, $1,500 a month, $2,500 a month. And then go from there. So I think the issue here is that this was intended to prevent landlords from saying the rental on this unit is well within the range of a voucher, but because you're getting a voucher, I don't want to talk to you. So that's what this is targeting.
Any other specific questions on this section?
Nope.
So, I suppose we can take 5 minutes just for open discussion on the bill of where people stand before I suppose we could entertain a motion if we're ready to have discussion on the full bill.
I'm happy to move for discussion purposes, that we vote draft 2.2 of S-103 out favorably.
Okay, discussion.
It is 2.2, right?
Mhm.
But
Yeah.
we do not have a later date.
Just, I think it's important and there are a lot of changes that are significant that will help employees, and I would suggest help employers by consolidating the regulations and the laws in one place and make it easier for employers to know the parameters of employment in Vermont, and it'll help them with larger organizations will be able to have very clear HR standards, human resources standards, which is important. So it's both protective and clarifying and consistent with existing case law.
Right. And builds on work we've done in this committee since 2018, where we
Okay.
first addressed this issue. So I support this effort and anything that clarifies and also helps get at some of the thornier cases that haven't been able to be taken up because of the barrier of severe and or pervasive. So I support this and hope it helps Vermont employers and employees alike.
Anything else? Yeah, I mean, I guess I'll just say, you know, we put our bills in different categories and silos, but I see this as a workforce development bill. You know, we have an increasingly diverse workforce. 90% of people moving into the state are people of color. We're borrowing good language from states that are very diverse and have, you know, a robust, generationally shifting, diverse workplace. And these are the kinds of protections that people want. This puts out a value statement about Vermont standing for equal pay and for a dignified and safe workplace. And I'm really proud of our work on this bill. I'm grateful to those who brought it forward, who do this work every day and see cases that we can't address without some of these changes.
Yeah, and just to build on that, I think that I think it was Julio that said this is what Vermont wants for Vermont, and that at the moment we do not have these values embedded in our statutes, and this would embed them in. We've been using, I believe it's either common law or judge-made law, as they say, and I think this takes these values of discrimination and embeds them in our that we won't stand for that kind of discrimination, and embeds it in our law, which I think is a good thing.
Great.
I'm uncomfortable with a few things
Okay.
in this bill. The potential of conduct that occurs outside the workplace is one that I'm uncomfortable with. It's outside of the employer's control. And I understood, I listened to the explanations that Julio provided as to what that means. And I'm still uncomfortable that this bill may go farther than we intend to go in terms of looking at things that an employer is responsible for and that is within the employer's control.
And Randy, where are you?
On page 6, and I'm really on the whole paragraph of lines 4 through 13, and specifically what I'm speaking about here is line 13. Harassment may be considered in the aggregate with various types of conduct based on multiple characteristics viewed in totality rather than in isolation. And item 13 is the conduct occurred outside the workplace. So that's one question. Now, I guess you could say, well, the Christmas party incident that occurs off the premise, for example, does occur outside the workplace.
Well, so does a conference. So does,
It does, yeah.
if you're traveling with fellow
I was
colleagues.
wondering in terms of how that gets interpreted in practice. I know what it says here in writing.
I mean, if the full committee wants to spend a couple minutes on that, we can. If that changes your vote, Senator Brock, we can consider it.
Conduct experienced by others outside the protected place involved in the conduct.
Does that, I mean, a conference that you go to,
Yeah.
something like that. But what about the local pub on Saturday night and everybody's doing karaoke and there's.
I think we're seeing this, you know, with the police, Vermont State Police
Yes, we
case.
did.
So I think in the court of public opinion, people are wanting to look at conduct outside of the workplace because it can affect trust that you have in law enforcement.
I
Julio.
can talk about how the law applies now, and I don't think this will change the law. Julio Thompson, Attorney General's Office. Longstanding law, and it's not just for purposes of harassment, this has to do with other aspects of employment law, things that happen off duty or outside the workplace. You have to show a nexus to the workplace that it somehow interferes with the person's ability to do their job. And there's a further requirement that, again, in the coworker context, that the employer knows about it and fail to take reasonable actions aimed to stop it from happening again. So other forms that happen, and frankly, this is the category of sex harassment cases we saw in the pandemic. We didn't have people in workforces. And so what were our sexual harassment cases? They were sexting cases. They were people sending lewd images of themselves in the middle of the night to a coworker. And if that's coming from your boss, the statute says, as the case law says, is that might, or you certainly can't say it doesn't. It can never be sexual harassment simply because it happens off the workplace. And a lot of court cases saying, we won't allow perpetrators to pick, the place of the crime in order to evade the law. But you do have to show a connection to the workplace. And if someone tells a dirty joke at a bar that's overheard, that wouldn't come close to violating the statute. So I don't think it opens, this doesn't change kind of what, the central doctrine, and it puts it in the statute.
Great.
Well, I mean, I can certainly understand that, particularly about conduct outside the workplace. You mentioned the state police case, for example. Well, that is a case in which there's no indication that the employer was aware that this conduct was occurring. I don't put that in the same class as this. I might put it in the same class as something that's inappropriate from the employer standpoint, based on the job these individuals are doing and the public trust. But that to me is different than what's in here about harassment.
Well, that's fair. I mean, now they're aware, so
Now
it could be that
that's a different
how they
situation.
handle it is.
But I think this covers a whole host of
Right.
places where we work together, but where we're not in the workplace. Could be at an NCSL conference or, any number of professional conferences or places outside the workforce you're required to be because of your work.
Just in Julia Thompson again, just for purposes of clarification, and I can't talk about pending state police investigation. That's not an employment case. There's no employee who claims that they were the target of that.
That's
So
fair.
this is really directed at target. And when you said that, or you raised a concern about conduct that occurs in the presence of other people, so that can be a case where, and we've seen these cases in around the country as well, where employer brings in a stripper in front of everybody, and it's in front of men and women, but because it's strippers of a particular gender, maybe the behaviors of the bosses or supervisors, that can be particularly degrading to people of a particular sex, male or female stripper. You take your pick, but the fact that it's in front of everybody doesn't mean that there's no way you can make a sex harassment claim. And the statute just says, as the case law says, is that might be a factor that you consider. Other common examples would be pinups and centerfolds in locker rooms that are available to everyone, but depending who's depicted, that can be offensive, particularly offensive or degrading to one group of employees. And so the courts have long said, the fact that it's everywhere, may even make it worse because there's nowhere to go.
Okay, so we have a motion on the table. And I'd like to move to a vote.
Okay, did you want me to call the roll or?
Yes.
Okay, so this is 103, an act relating to amending the prohibitions against discrimination.
Draft
Draft.
2.2.
Draft 2.2. Senator Brock,
Yes.
Senator Clarkson,
Yes.
Senator Cummings,
Yes.
Senator Harrison is a yes, Senator Ron Hinsdale.
Yes. I am really proud of a unanimous vote on this bill. I did not know where we were going, so thank you, committee.
And I'll put myself next to the
Yes,
reporter.
yeah. Yeah.
That's great. I was good. That's terrific, Wendy. Good bill to present.
Great. Okay, so we have a whole 40 minutes on S102. I believe we voted S30. And we can, so I just want to say we could take all those 40 minutes on S102.
Well, that's good.
We could see how we do. I don't know where Ellen is and if she can come in before.
She's booked at 11.
She's
right?
booked until 11. We can double check, but I'm just saying, I know people are anxious to get to the natural resources amendment. We have a half an hour for that right now, but of course we get interrupted at the end with the Senate vow, so we have about 25 minutes. If we get through this sooner than 40 minutes, we can see if Ellen can come in and I can do my best to start walking through the amendment. That might not be a great thing, but we'll see how we do in the next 40 minutes on 102.
So I just sent, I sent copies of the amendment to the committee. I'll pull it up on the screen. For those of
And we're
you,
all looking at 2.1.
yes,
That Scott just handed us.
yeah. Okay, so the big change in this draft from the last one is that we took out the free speech language from 102 and replaced it with the language that was in 106. So the main change you'll notice right off the bat is there's no reference to the First Amendment or the parallel provisions of the Vermont Constitution.
And just to clarify, that had come from Connecticut reading of how to write this. And so, you know, it
Yeah.
wasn't a big, huge policy decision. That's still covered. We just thought that could be getting stuck on that, like what kind of free speech is going to be included. And that's a kind of hot button way of framing things.
Right, right. So there were two different bills that those two were, or two different state laws that those two are based on. 102 followed Connecticut more closely, and then 106 was based on Oregon's law. So this is this tracks with that. So the main pieces in this now are that an employer or the employer's agent is not allowed to penalize or discriminate against or threaten an employee if the employee declines to attend or participate in an employer-sponsored meeting that has the primary purpose of communicating the employer's opinion about religious or political matters. Or the employees also cannot be penalized for declining to view or participate in communications with or from the employer or the employer's agent that have the primary purpose of communicating the employer's opinion on religious or political matters. No First Amendment piece.
Okay. But what we've really been aiming at is, and what I understood the Connecticut suit was partly based on, is are we saying that labor unions can talk to employees, but the employer is not allowed to voice their concerns about a labor union, that only one side is protected?
So under the National Labor Relations Act, under Section 8 of the National Labor Relations Act, which governs unfair labor practices, both unions and employers are allowed to talk to employees and to discuss their position on unionization, organization of the bargaining unit, et cetera. Subsection 8C of that provides that right. The First Amendment, our Supreme Court has held, also provides the right for both of those organizations to express their opinion.
Okay.
That right stops at when there's coercion involved. The issue here historically has been where the line of coercion is, depends on who's on the National Labor Relations Board. And that that changes with the administration in the White House. So you can imagine it's a politically
It's a shaky
appointed
line.
board, and the line moves.
Yeah.
But the basic law underneath all of that is that an employer and an employee organization, a labor organization, cannot use coercion to make their point, but they do have a First Amendment right to make their point. What this is saying in this bill, and this is where there's a question, is does that right extend to requiring employees to attend the meeting, or just saying, I want to discuss the labor union, but you have a right not to attend or listen? So that's the question in this bill. That is not decided yet. So there is a Connecticut case, which is at summary judgment. The motions have been filed, the court's considering it, but at this point, we don't know how the court's going to rule. In Oregon, the state that this language is based on, their law has been challenged 3 times since 2009. All three of those cases, though, don't help us because they were all dismissed for lack of standing. The plaintiffs in those cases were, in two cases, were the National Labor Relations Board. In one case, it was a broad employer membership organization. In all three instances, the court said, you don't actually have a concrete harm because you're not a party to these conversations. So we don't have a chance. We don't have the authority to issue an advisory opinion. We need a concrete allegation of harm before we
So
can
you
decide
basically
whether
need
you're
an
protected or
employer
not.
Or an employee to
And
say,
to date, as far as I can tell, that hasn't been challenged. In Wisconsin, there was a challenge. Again, it didn't get to a court decision. The Wisconsin decided to settle the case and not enforce the law. So that was a decision by the Attorney General's office in Wisconsin that they weren't going to fight the law, and the governor's office that they weren't going to enforce the law. So we don't have a court that came out in that case one way or the other. So the issue for us here is with the labor organizations, we don't know if we're preempted by the National Labor Relations Act. If we are, what that would mean is that that language couldn't be enforced. If we get to a decision in this case in Connecticut, it would be eventually it would go to the Second Circuit, presumably, and then we would have binding law. So,
okay,
so that it's an open question. I can't tell you one way or the other. It is on the books in some states. In Oregon, it's sat there for a long time, but there have been 3 attempts to overturn it. They just haven't gotten past the standing stage.
okay. I just want to make sure I have to think this is still a democracy and everybody has a right to be heard. Nobody has a right to coerce. But the unions are allowed to greet people at the water cooler or, yeah, right? I just want to make sure that the employers have an equal right to, can an employee say, no, the boss says, will you come in and can I see you for 15 minutes, come into my office, and have the employee say no
So there's
on the payroll?
2 things in that. One is under the National Labor Relations Act, the employers have a protected right to express their view and to make their case. There was a question that came up about card check. That's not permitted under the National Labor Relations Act. The general counsel of the National Labor Board, the current general counsel, is encouraging the board to allow card check again, but at present, it has not been permitted. So, and then the general counsel and one of your witnesses yesterday spoke to this issue. The general counsel is also encouraging the labor board to review its precedent on these captive audience meetings and how coercive they may or may not be. So I can't comment on that beyond that to say that it's right now you're allowed to have an employer meeting with employees under the National Labor Relations Act as long as it's not coercive. So there can't be threats. Like if I see you talking to the union, you're fired. And obviously there can be a lot of other threats. You could talk to advocates on either side about what that does or does not look like. I'm not a labor organizer and I'm not involved in these discussions, and I don't want to share anecdotes for fear of coming down on one side or the other inadvertently. But right now the law is that you can make your case, but you cannot coerce.
So
Within
that's the
this,
federal law.
that's the federal law. Within this draft, there is specifically an exception. There are several exceptions, which is probably worth revisiting. So I'll pull those up on the screen now.
What page?
We're going to be on page 2. So starting here, the first exceptions are just that this section doesn't affect an employee's rights to bring a civil action for wrongful termination or diminish or limit any rights under a collective bargaining agreement or employment contract. So that's the first part. So that's page 2, middle of the page. Going to subsection C on line 12 of page 2.
Yeah, got it.
This section doesn't prevent a religious or denominational organization from communicating its views on religious matters. And then going to subsection D on page 3, same thing, but for political organizations on political matters. And then subsection E, which gets to your point or your question, nothing in this section is construed to prohibit an employer or the employer's agent from communicating information to an employee that the employer is required to communicate pursuant to state or federal law, or that is necessary for the employee to perform the employee's job functions or duties. So the question with respect to that meeting with the manager is the manager communicating to the employee about the employee's job functions or duties? For example, if I was the employee, is the manager calling me in to say, Damien, you know, you've been late with your reports for the last 3 weeks. We need to address this. Or is the manager calling me in to say, I want to talk to you because I saw you with the union organizer? There's 2 very different things here. Or I want to talk to you about voting for my preferred candidate for the Vermont House. We're talking about different things. If it's the political thing or joining the labor union, this bill provides me with the right to say no. When we get to the question of the National Labor Relations Act, the question is that closed door meeting one-on-one with my manager coercive? And I can't answer that question
Coercive is
for
in
you.
the eyes of the beholder, freak. I mean,
And
if it
it's
says I'm
gonna be
gonna
in the eyes
fire
of
you.
the,
But then if I've got a 6'2", 300-pound union organizer and I'm 5'2" and 18 years old, is that saying, you know, you really need to sign up for the union? Is that coercive? I'm trying to make sure we get
It's
a balanced field here.
so that the answer is those questions of coercion are with a private employer are decided by a federal body under federal law.
So it's a court, so you have somebody,
Then there's federal precedent and case law that would be applied on that. So we as a state don't control where the line is on coercion for that. We do control it for public employees. We may control it for some extremely small private employers who don't work in interstate commerce, if those employers exist in Vermont. But in general, that's a federal question that we don't have power to decide, and this isn't going to change that federal law. Whatever we do, if we step into something where federal law controls the field, we'll be preempted. And otherwise, if we don't cross that line, if the courts rule that this is not crossing that line because it's still an open question, then what this is basically going to say is that if an employer wants to meet with its employees in a non-coercive setting to discuss their views on the unionization issue at that workplace, then employees would be free not to attend. That's all that this would do, assuming that's not preempted under the federal law. And I can't answer the question for you whether it is. And I don't have a good opinion at this point as to whether preemption is likely or not, because the way these cases have gone, we've never gotten close to a decision. So that's really where we're at on this. And I think, you know, even in the example you were given with a large individual speaking to a smaller individual or a
Younger,
young individual.
smaller.
It's gonna be case by case. What's the circumstances of
But
that
it
conversation?
will require that young 18-year-old female file a complaint with whom? The National Labor
Well,
Relations
so
Board?
usually these complaints are brought by the employer or the union. So they'll make an allegation of an unfair labor practice to the labor board and they'll do it through their
But
lawyers.
it's
It's
gonna
not the
require
individual.
that the employer is going to have to know that on their way home after dark, the union folks. I mean,
Right,
it
but
works
it-
both
it's-
ways. I'm
it's-
sorry, and I'm having a really hard time
I-
feeling that I can't ask questions without being labeled. I think I have an obligation to know.
Right,
I've been here long enough to know that nobody is lily white and that nobody doesn't use unfair practices at some point.
I just want to pause us and, say, I think it would be helpful though, just for our full audience, if we talked about behavior and not someone's appearance or, weight or height. With permission, Scott reminded me he needs that exact dimension
Yeah.
that you mentioned. And, I don't want to,
And if Scott
Like,
got within my personal space when I was 18 years old, I have a lobbyist who does that. And I've had to say, back up, that it is threatening to have somebody that is twice your height and
I just think if someone gets in your face, regardless of their physical characteristics, we can talk about that, but I just rather we not, really try to use other things that are out of someone's control to talk about, how they might be extra scary or intimidating, because that can get us into really
that's what we
murky
just,
waters.
yeah, but that's just what we just talked about in the last bill.
We
I'm
talked-
saying I want to make sure that in barring coercive practices,
Mhm.
that we are barring coercive practices on both sides.
Right,
That my job is to level the playing field so that everybody has a right to make their case and be heard.
right,
That's the way I see it.
yeah.
And I want to make sure that as far as possible, that this is a level playing field
Sure.
and that that's what we're doing.
I just know I'm a 5'1" female and I scare people a lot, it's much more about my behavior than it is about, my stature and I'm also a chair of a committee and on and on. So, status and title and you're paying someone versus, or it being after dark, whatever the case may be, that's just is a different thing. And I think it would help all of us if we stayed focused on behaviors.
right. So I think
Well, and
the-
intimidating behaviors are unacceptable. both
The
ways.
Yeah.
bottom
Whatever.
line is
No
that
matter.
regardless of who engages in the behavior, both parties under Section 8C of the National Labor Relations Act are entitled to make their case.
Right.
Right.
So Section 8C has been read by our courts to sort of recognize the First Amendment expression rights to make your case for or against unionization in the workplace. It does not extend to coercive behavior, and there are limits on this. And I think the point I'm trying to make here is not that is not a point about whether the limits are good or bad or whether that should change, because it is a hotly debated issue. And I don't want to take anything away from that. This is a hotly debated issue, and I think advocates on both sides of the issue could bring forth anecdotes of particularly bad behavior that makes the point that where the line is right now it is often crossed, and it's not always enforced effectively. That being said, as the state, we are not allowed to intrude on the field that the National Labor Relations Act has occupied. Whether this bill in front of you will do that is a question I can't answer for you right now. It has been challenged. So far, we don't have a clear reading from a court as to whether those challenges are going to be upheld. And I think there are lawyers on both sides who are making compelling arguments as to why or why not it should go forward. And I am not well enough versed in this to give you a reading as to, well, I think it's 70% likely that the court's going to go that way, if it even gets to a decision. What we've seen time and time again is either the challenges end at the motion to dismiss stage because of a lack of standing, or the parties settle out of court, which leaves us wondering, where's the line? With respect to the cases that Senator Cummings is bringing up, in those cases, it is typically the union or the employer that will then go to the board and say, hey, they're not playing by the rules here. They've been accosting employees outside of work, whichever party it is, or they've been calling employees into closed door meetings, or they've been intimidating them, they've been harassing them. And then it's up to the board to make a decision. Is the behavior being complained about coercive, or is that protected speech? And unfortunately, this is the sort of thing where just reading through the cases here, and as I mentioned, the board changes and the line moves a little bit over time. It's hard for me to draw a line where I could say consistently every single time, this is going to be upheld, this isn't going to be upheld. I think it's clear when there are threats of physical violence, threats of economic violence, or economic damages to people. In that case, you get to coercion. When it's more gray area, where there's disparagement of negotiators for one side, disparagement of a workforce that's either unionized or not unionized, the line gets grayer and the question starts to get closer. What was said? How was it said? What was the environment? And unfortunately, we could probably spend a semester in law school discussing these issues and where the line is and what the appropriate law is. And but this morning, I'm not sure I can answer your question clearly, except to say that this isn't going to change that debate or the way it's resolved as to how the individual who's intimidated on their way home or at their home by someone representing one side or the other, it's not going to change that question. And as a state, we don't have the power to do much about that unless it strays outside of labor into something like criminal law.
Right.
And God forbid it does that. But in this case, I think there are two sort of key questions on the bill in front of you. The first is just sticking with the labor issue, is whether you're concerned about leaving membership in a labor organization as a political matter under the definition. So you can tweak that definition, which currently applies to political affiliation, elections for political office, political parties, legislative proposals to change rules or regulations, and then the decision to join or support a political party or a political, civic, community, fraternal, or labor organization.
So, sorry, you're on page 3.
I am on page 4 now. I'm
Page
sorry. Thank you for
No, I'm
stopping
sorry.
me
I'm
when I do
trying
that.
to follow you as closely as I can.
And
as we're
so
getting close to voting this.
The first question,
Got it.
is-
Okay, we're on 1.
the first question is probably, do you want to keep this captive audience meeting language in here at all? And if you do you want to change the definition of political matters? Because I think it's either overbroad or not broad enough. And so as it is right now, what this bill is prohibiting is the employer from mandating meetings where that have the primary purpose of expressing their opinion on a political issue or a religious issue, unless they are a political or religious organization, in which case they can, if they're staying within their sort of purpose of either political or religious purpose, they're free to express their opinion, because that's you as an employee, you go in knowing that you're working for that organization.
I just,
Yeah.
Liz is right out of my line of sight, but it
Yeah.
seemed like she might have wanted to say something in this exchange. And if there's anything you wanted to add while we're.
Well,
Before,
so many things, but first I would say, you know,
Liz
I
Medina.
think Damien did a great job covering the NRA and the coercion piece, so I actually don't have anything more to say on that. I would say that the intent of the bill is to address this problem, which you saw many witnesses testify about a few weeks ago. And so I think it is pretty important to keep labor organization in there. That being said, unless of course the labor organization, and I don't want to make any assumptions here, but this would be out of my purview. I would want legal advice on this matter, unless the labor organization can fall under the category of fraternal organization.
I think that in some cases, yes, in some cases, maybe not. And I am not sure where we draw the line. So if, for clarity purposes, I would say if your intent is to capture labor organizations, I would keep the word labor organization in there. Because, you know, we do have labor organizations that call themselves a fraternal organization, and we have some that don't. And I don't know where to draw that line. And I wouldn't want it to be an issue of semantics if the intent is to capture labor organizations, but the language isn't there.
Senator Torres.
I'm fine with the language as it is.
I'm glad we had this discussion. But I think unless someone, after the full discussion, wants to move to remove that word and we take a vote to call that question, I think we'd leave that as is and just see if people have questions on the rest of it.
Well, I have a couple of
Yeah.
questions. One of the questions is let's say a corporation, business is dependent upon government contracts, such as a pharmaceutical company, for example, who sells a lot of stuff to Medicare or Medicaid, may well have a business interest in seeing particular candidates elected who tend to support what they believe in or what their company is trying to do. That may in fact extend to political parties. And those aren't the only kinds of organizations, corporations, to whom whoever is in charge of particular parts of government can be either very favorable to or very opposed to their business interests. I'm concerned that some of these restrictions may prevent businesses from conveying that information effectively to their employees, who obviously are instruments, if you will, to support what they want or need to do or believe they need to do for legitimate business purposes. Is that an issue in terms of how this language reads?
So there is a little bit of, so looking at this, it brought to my attention, one, that I didn't finish saying the types of meetings that an employer can require. The next is, there is also that an employer can require an employee to attend a meeting to discuss issues related to the employer's business or operation, if the discussion is necessary for the employee to perform the employee's job functions or duties. I don't know if what you're describing meets that, which would put them under the third exception, which is that they can offer meetings on a political or religious issue if attendance is voluntary. And they would have to make it clear that attendance is voluntary. And that, I think, is where those meetings that you're describing, where, you know, we're dependent on this contract with the federal government. You know, we have a contract to produce whatever for the federal government, or we provide a service. And candidate X supports the continuation of that and candidate Y wants to cut the program. And so as an employer, I have a business interest in seeing that candidate X is elected. In that case, I'm not sure it falls under the language of necessary for the employee to perform their job functions. It might, if you were, say, a government relations manager for the company or something like that. But for an employee on, say, the assembly line, if they produced a product, it would likely be, this is a voluntary meeting. We'd like you to attend, though, to hear about, plans to expand this program or whatever it is.
Well, I'm thinking though,
Yeah.
just the more practical, we want candidate X elected. And so therefore, we want all of our employees to vote for candidate X. And we want to tell you about candidate X and why it's good for our business and the continuation of the jobs and prosperity that we have.
Right.
That
And
would fall based on this language on having to be voluntary, that you couldn't have a meeting to do that, even if
Yes.
it's a paid meeting that is part of the normal workday. Now, that leads me to the next question is, if it then becomes voluntary and the employee decides that they don't want to go there, does the employer have the right to say, well, obviously, we're not going to pay for that time? That may have been part of your hourly work week because we're going to shut the machines down during these 2-hour period and not pay the employee for that because they declined to attend that meeting. That was part of the employer's workday. Can they do that?
well, so that gets into a bigger question on wage and hour law.
Yeah, I mean, if it's
So
a
that-
salaried employee, that's one thing.
And
I'm talking about an
retaliation.
hourly employee.
Yeah.
And yeah, so that's another good point. So there are really two issues there. One is there are questions with wage and hour law. First, if it's a salaried employee, there's likely not that issue, but if they're an hourly wage employee, you have questions of whether the employee is essentially being required to be on call during that time or whether they're free to use their time as they wish. So could they leave the plant or the office space? And that's going to make determinations on whether under federal and state law they're required to pay wages, even if the employee is just sitting at their workstation doing nothing. The next question that you get into, and this would be somewhat harder to figure out, is that retaliation where we'll pay employees to attend a meeting on Tuesday, but anyone who doesn't attend the meeting doesn't get paid that day. This saying it's an all-day conference or something like that. And that it's hard for me to come up with a clear answer to that because there are different things that could factor into that. Is it a day off for employees? Is it a voluntary thing where, hey, we're going to close things down, so everyone's going to have the day off. If you want to attend this other meeting or training or whatever it is that happens to, convey our opinion on a political issue, it's really hard for me to answer that. It could potentially be just retaliation or viewed as retaliation, penalizing employees by not paying them.
Julio also has a.
Yeah, so
you wanna-
It's not really a comment about the bill because the Civil Rights Unit hasn't been involved in this bill, but it's about existing labor relations law. So Vermont, since the earliest statute was the State Labor Relations Act in 1967, and state employees in 69, and municipal employees in 73. All of them contain a provision about freedom of expression that applies to workers, to unions, to employers, to organizers. And all three statutes say that speech is protected provided it doesn't involve a threat or a promise of benefit. So you can't bribe or use. So under your example, a question that might arise under existing law, if this bill doesn't exist, there still might be an issue as to whether employer says, we'll pay you if you come to this meeting, whether that's one of the, is that a violation of existing law about whether you're providing a monetary benefit for people to hear your side.
It's also kind of a threat if you say, we're not gonna pay you
Exactly, that's
for the work
Yeah.
day,
And I-
unless you not come into this.
And I think that, so that's existing law. And
Yeah,
for-
right, exactly.
For government employees, it would also be an issue about First Amendment retaliation that at least would be raised under existing law. An employee says, I don't, this isn't related to my job and I don't want to be part of it. I just stay out of it. And then you lose money as a result of that. That could be characterized as a constitutional violation. It would depend on the facts and you'd have to find it out. But I'm just saying, under existing law, that would already be an issue. That's all I wanted to say. And on the issue of coercion, to return to Senator Cummings' point, feeling physically intimidated by a union organizer has been covered in Vermont since the late 60s, early 70s. It's already in the statute and this doesn't change that.
Thank you.
Great.
Any other
Thanks,
questions?
Julia.
Megan?
Sorry, Megan Sullivan, Vice President of Government Affairs for the Vermont Chamber of Commerce. I did want to just bring up again, the Florida law, which was considered a captive audience law, was challenged on First Amendment rights and stopped on First Amendment rights and not on the Civil Rights Act, because DEI training goes far beyond that. And so and to say that that's not political is certainly not how the state of Florida characterizes it. And I'm sure there are people in Vermont that would agree, unfortunately, with the state of Florida.
So
I think I'll just go to Senator Parks.
No, I think you're gonna say what I was gonna say, which is if it's law in the state, it is not a political act. That is training on the
Is
law.
DEI training mandated? in the
So-
Vermont?
No, what I was gonna say with Florida is that law is distinguishable from this one because Florida specifically specified a viewpoint in it. And so the court there found that it was facial viewpoint discrimination because they identified things that employers could not say. So if the employer had that viewpoint, so essentially what the decision, which I've got here, says is the IFA is the inverse. It targets speech endorsing any of 8 concepts and only incidentally burdens the conduct. So the slightest endorsement of any of the 8 concepts at any required employment activity violates the statute. However, if you endorse the opposite of those concepts, you are allowed to speak. And so it wasn't the conduct of holding the meeting that was at issue. It was the fact that you could have a meeting that was, in this case, in Florida's case, it was, for example, where it was an anti-critical race theory meeting, where you couldn't have a meeting where you espoused or supported or endorsed critical race theory, and a variety of other concepts they set out. So that was where Florida's law didn't just, that's what it was struck down on, was the fact that they said you, as an employer, you can't train or endorse or promote any of these 8 concepts. And they were, and so the issue for employers was, well, if I have a DEI training and I speak about systemic bias, am I endorsing it now? And so employers were curtailing their speech, and the court said the fact that employers are curtailing their speech or hiring attorneys to figure out what they can and can't say means that their freedom of speech has already been impaired. In this case, and this is what the Connecticut case is going to, and it's not a settled point, is the fact that we're saying that employers can't require their employees to attend, and that's what's being asked in Connecticut. In addition to the NLRA question is the fact that we're saying that employers can't mandate their employees attend a meeting, does that infringe on the employer's ability to express their opinion as protected by the First Amendment? So I'm glad you brought that up, because the question is, by saying you can't have captive audience meetings, does that infringe on your ability to speak, period? which is different from Florida, where it was outright saying, if you have any viewpoints, it is illegal for you to express them in the workplace.
Right, which we
Which-
can have a diversity training and someone could say, I don't agree with this, and I, think this is, whatever, they can
Right.
say something, we're not censoring.
So the question, and I think the question that you're getting to is, could someone bring a lawsuit against an employer here saying that you can't require me to attend this because anything related to diversity or inclusion training, whether it's implicit bias or DEI training or even sexual harassment training, that's a political issue and I don't have to listen to your opinion on that. And I think the courts in that case, it's a question of them training on compliance with the law and the
Yeah.
employer's policy versus the employer's opinion, because the employer's policy may be insulating them. I'm not saying the lawsuit wouldn't come, but then the other question, that probably the more likely question is, does the fact that we're saying that employers can't require their employees to attend, does that infringe on their First Amendment rights?
Mhm.
I can't say how the Connecticut court is gonna rule on that. I think you're likely to have more, well, it's hard for me to say what's
Mhm.
likely or not likely in a
Yeah,
court
our
decision.
courts are like a hard place right now to look for
It's,
the kinds of answers that Vermont
But
wants, and
that-
we sometimes just have to do what we believe.
I'm
is
glad you
right.
brought that up because I was focusing on the Section 8C piece of that. It is still an open question whether, and again, all of these court decisions have not gotten to the point where we have a clear indication
Mhm.
from a court in any jurisdiction in this country that I'm aware of that says captive audience restrictions are either are or are not, and there are arguments on both sides, either are or not infringing on First Amendment rights of employers, because just like individuals, corporate entities and business entities have a right to express their opinion.
Mhm.
The question is, do they have a right to require their employees to listen to that opinion?
Mhm.
I don't know the answer to that.
Right.
Um,
And it
Essentially,
sounds,
there's no court decision anywhere that seems to resolve that.
Not that I'm aware of. We have settlements, but that's not the same thing as binding court precedent. If we're lucky, Connecticut's case will be resolved, go to the Second Circuit, and we'll have a clear binding precedent in our circuit that tells us one way or the other, but we don't have that right now.
and I imagine if some decision should be made, we would probably want to take that issue up in case we wanted to be as clear as we can about where our law stands vis-a-vis what. the court
Yeah,
has
I
to
mean,
say.
if you were to enact this,
Mhm.
and then the Connecticut decision came out and said either it's preempted by the National Labor Relations Act, or this is an unconstitutional restriction on speech, our law would have to follow
Right.
that decision.
Mhm.
So either we couldn't enforce it with respect to the NLRA, or we couldn't enforce it, period.
Mhm.
And
And
so
those are the
then,
arguments that are in the Connecticut case right now.
as I understand it, the two arguments in the Connecticut case are, one, that it's an infringement on First Amendment rights of employers,
Mhm.
and two, that it's preempted by the National Labor Relations Act. And I can't say how it's going to come out, but I think both of those they're both arguments that have had strong arguments made on both sides. I think the difficulty with the Florida law is it had such a glaring flaw with the viewpoint piece. The court never went to any of the other issues. The court said, and this decision is one of the most strongly worded decisions that I have seen in a long time, where the court in the opening paragraph said this is not even a close case because the viewpoint discrimination here is so blatant.
It's like a threat to democracy at that.
And they passed over all of the other issues that were potentially in the law, said you can't enforce this because of the viewpoint issue. And if we had something in here that said, you can't express your opinion if it is pro-union or anti-union. I would say clear First
Yeah.
Amendment violation. Because it's across the board on political issues, it's harder to say because it's not a viewpoint issue, but there is definitely a First Amendment question. We're talking about speech, and we're talking about speech on political and religious matters, which is something that is deeply cherished in our democratic tradition. So I can't tell you how it's going to come out, but I'm glad that Megan brought that issue up because it is another question.
So,
But, and just to clarify, but anything that is actual law in Vermont and come, an employer is able to train to that compliance
So
for that. compliance.
under existing law, there's nothing that prevents an employer from training on their policies, and their policies are protected under this because that's part of how the employee has to do their job. So if you have an anti-discrimination policy, if you have an equity policy and you want to train on that and compliance with that, as an employer,
You're able to do that.
you're able to do that, and you're able to fire your employees for not complying with that
Right.
policy. So that is bottom line.
Right.
If you have a policy that says, you know, for example, here at the State House, we have a policy that goes beyond the state law
Right.
in terms of what's protected in, for employment discrimination. We have a policy that expressly says it need not be severe or pervasive. The intent of that is to avoid ever getting to a point where we have a case before we've done anything about it. And we as an employer are allowed to train employees on that policy, even though it goes beyond what the state law requires as a minimum. But that's because that's our policy in the workplace for how people conduct themselves. And we have the ability to terminate employees who violate that policy.
so yeah, I want to do like a 2-minute time call because
Yeah.
I think people want to go home this weekend and at least have heard well, period. But also, go to the floor and also hear what Alan has to say about the natural resources amendment. We will not
Yeah.
vote on the natural resources amendment today. We don't need to do that today, but
Why not?
well, it's still going to appropriations next week. And
Oh, because we got both pieces out.
yeah,
Committee.
we're not required to, nobody's needs our
nobody's-
vote today.
Okay.
And Senate Natural Resources is working on a further amendment to clarify some 11th hour language that
Oh, right,
that-
right.
they want to clarify, but I think people want to go home this weekend and know what's in the Natural Resources Amendment to S 100.
Yeah,
I could be,
yeah,
So
no,
just-
because you guys have done good work on
um,
it with Chris.
I'll let everyone decide for themselves, but
So this other one, we do need to vote.
we
on,
need to
right?
vote. Yeah, so the
So
question.
hard check remains in here as far as
Mhm.
going forward.
Do you want to, I mean,
Do you want me to make a motion so that we can discuss
if
and
people
or
are
vote?
done asking clarifying questions, we can move to brief discussion.
I'm happy to move it if you want.
Okay,
I would move that we vote out draft 2.1 of S 102 favorably.
any discussion? Okay,
Senator Call,
yes,
Senator Brock,
No,
Senator Clarkson,
Yes.
Senator Cummings,
Yes.
Senator Harrison is a yes, Senator Ron Hinsdale.
yes.
Okay, so it is 5-1-0. 4-1-0. I'm sorry.
I have my spidey senses say maybe Senator Clarkson will support this one.
Oh, I thought you were going to.
Oh, do you want me to?
I think you should.
Okay,
I think it would be a good one for you to do. Probably do it in your sleep.
I don't get much sleep anymore,
Good.
but sure thing. I'm happy to report S
now
102.
this will not be listed as a committee bill, will it?
No, it's S 102. It has been
It's-
introduced.
Oh, it says the
This is a committee
It's
amendment.
listed as a committee
Is-
bill,
It's a,
It's
a
a
strike
committee
all.
strike all
or
amendment.
committee strike.
Yeah.
okay.
Yeah,
the kind of
so
standard.
it's the report of the committee. So,
And it not only makes changes, but takes out good cause termination at this point, so I didn't have an issue with
yeah.
this being.
And Scott, I think I sent you a clean version of this already. Okay, good. It's hard to keep track.
Okay, we have gone through
Great.
our votes today.
Ellen, the seat is nice and warm. So
Although there are no goodies left.
then
Oh.
do you,
I know that is,
No,
do
there's
you
like,
want the leftover
some
monkey
gluten.
bread?
No, Damien is dying to finish
wow,
that.
yeah, that's quite the offering.
I think there's a lot of brownies in approach.
Oh,
Oh, thanks, heads up.
Damien, thank
There
you.
were earlier
Great,
this
thank you for your
That
time.
was a significant amount of content
Brownies for breakfast.
to get through.
morning. They
this
were there
week.
yesterday afternoon.
Thank
and
you.
they
Oh,
were
right, I
last
saw.
I appreciate everyone chiming in from behind me.
It's a lot of case law right now. Most important.
It's nice to have
Who's next
some
to
backup.
Get out.
Yeah.
Thank you.
Thank you, Damien.
So we will switch gears to S100. Preemptively thank Ellen because she's been ping-ponging around in this bill quite a bit. And we appreciate all of your work.
Thank you, Julio. Thank you, Liz. Thank you, Megan.
Hey. Ellen Schakowsky, Office of Legislative Counsel. I am here on S100 and the committee report from Senate Natural Resources and Energy. It's draft 3.1 dated 3/15/2023. Also, I believe Scott has a summary of the amendment, which will be helpful. So in draft 3.1 of Senate Natural's amendment, it's an instance by instance set of amendments. So you looking at S100 as was voted out of this committee will help you because it's not a strike all. So it's only showing some of the language. But that's also why I have the summary document for you,
I
just so
think
you
the
have.
summary is good to work on with.
Give people what
15.
people's, but I think with
You
the
have
time
both.
we have left, we should probably do summary.
Sure.
And people can follow along.
Sure.
So the first instance of amendment is in the required density section. It's in section 2. So you will recall that in areas with residential development, zoned for residential development with sewer and water, towns are required to allow up to 4 units of development under 4 units of housing. And that's what your committee voted on. The Senate Natural Resources Committee is raising that to 5 units per acre. And that was the number you all had discussed for quite a while. They wanted to go back to the increased density.
And they are required.
The density,
The towns are required to allow that density.
yes. Unless they still kept our exemptions
Yes.
for places that you don't want to develop for.
Right, and then they have to be served by sewer and water. So that's a,
Yep, so it still is related to sewer and water, and your provision in section 2 does allow the towns to define what that means in their town.
On sewer and water.
Yes, served by sewer and water. So
There
there
were
was,
those exemptions.
yep, so they can address areas that have constraints, that have areas that have existing permits on them that don't allow for additional development or physical sites, site constraints. So there is the ability of the town to shape that exact area based on their town's specific issues. So the second instance of amendment is swapping out the language that you had in section 6. This is the section that relates to who can appeal a municipal decision. Under your version, you had struck the language that would have allowed any combination of 10 voters or property owners from appealing. The Senate Natural Resources has unstruck that language, but they narrowed it. So they narrowed it to any 10 persons with with an injury to a particularized interest protected to the chapter.
So what is that?
So that language is what is currently used under Act 250 appeals. It is narrower than the language that's currently in the municipal appeal section. So there needs to be an injury that has happened. It has, and the phrase
Is the injury, I can't snowshoe on this piece of property anymore?
So the language is vague. Potentially, it does require a common injury of those 10 people, so they have to have a shared
Okay.
common injury.
Yeah, they all can.
So could a common injury be a concern about the appearance or the change to the general appearance of the area?
Yes, I think so.
So it could be, in effect, very, very broad. They just don't like it.
Potentially, yes.
It really doesn't change.
But it has to
anything.
have 10 people saying the same thing.
It
Yeah.
does now,
10 people say we don't like it.
yeah,
But it's the same as the current Act 250?
yes.
Now, this is
So it's
This
not
is
a-
just taking it back to current law.
No,
not
it's
a
not.
change at all.
No, it's not changing it.
So I will say that it is using the, I think that under current statute in Title 24, the municipal appeal section is broader than what is under the existing Act 250 section. So they took the language from the Act 250 appeal section and put it here in an attempt to
applied it to
narrow.
municipal.
What is this? So is this the appeal to the municipal, to, who are you appealing to? You don't like, so the select board says, yes, it can go, or the planning board. You appeal it to whom? Court or to the,
So it's
District.
every stage of the municipal planning process. So yes, the first step would probably be the review board or whoever the board is at the municipal
well, they
level.
make the finding. You don't like the finding.
Right.
You don't want a parking garage because someday, some of you hope you put a park in there. So you appeal that to court, to Act 2. I'm trying-
Not Act 250, but any stage of the level of appeal.
So it could go to the environmental court based on the fact if you believe that it damages the character of the area.
Yes.
Yes.
But, so that is existing law. This is a slightly narrower version of the existing law.
And that's what we tried to fix by eliminating the 10 altogether.
Yes.
Mhm.
So this, but it narrows it from the broader municipal appeal opportunity.
So it is narrowed language.
But very marginally now.
Very,
Mhm.
I don't like the character. Bill.
Ellen can't speak for the committee, but
No,
yes,
we do not shoot the message.
right.
Meeting.
So the third instance of amendment relates to the energy code section. What they did is they struck the second half of the energy code language. So the language that you passed said that towns could not adopt a more stringent energy code unless they had a municipal charter. But then your language also set up the second process by which DPS could approve a more strict energy code if they went through a specific process. Senate Natural Resources struck the second process using the Department of Public Service approval and just left it with towns can adopt a more strict energy code unless they have it in their charter.
So then towns can have all kinds of energy codes that are more restrictive to use as a means of preserving NIMBY if they wanted to.
If they have it in their chart, if they have a charter and adopt it in the charter change. So that was part of what you passed. And so they didn't change that first part, but they got rid of the second part going to DPS.
Seems like that would be counter to their goals, but who knows?
Well, what I heard was they wanted a stronger energy code. I mean, that's part of their mission. But what we heard from folks was that the variety of energy codes is not, does not help development happen.
That's right.
So for creation of housing on its own, I would see this as a negative change.
That's correct.
But consistent with our objectives of creating more efficient housing that is healthier and begins to move us off of fossil fuels, and it consistent with all of our efforts with Efficiency Vermont and weatherizing things. And, we're spending a fortune. We can't have it both ways. We can't spend, the money that we're spending through Efficiency Vermont to weatherize everything and then not require things be energy efficient and weatherized and.
What we did was we eliminated, and our goal in all of this is to increase the production of housing and to do so in an affordable way in the short term because of our critical need. This allows towns to create more restrictive energy codes, which will make for more costly housing and will make less of it.
So I would just
I
say though
wouldn't
that
say-
this is narrower than what your committee passed. This is only for towns with charters, whereas your language would potentially allow for other towns as well.
Right, that was the big change with us, is that we lifted it towns with charter requirement.
I'm trying not to be too heavy-handed as we
Yeah.
look at this language for
Okay,
the first
sorry.
time.
Okay, so.
But me personally, I think other people can, but that committee was about to strike this whole section, and
Right.
then they continued to talk to the housing advocates about finding new common ground. So,
Right.
but I just want to let people see
Okay.
these for the first time without me chiming in.
The compromise is we're only going to take out half of your teeth instead of all.
Right, exactly. Hey, and this is not the house.
I don't think this was, well, whatever, yeah.
Yeah,
I'll-
okay, so fourth,
There
because we
was
have
things.
5 minutes. We have 5 minutes.
So fourth section amended the Act 250 section. So your Act 250 section had a few different Act 250 changes in it. They changed your changes. And so they have similar proposals to what you did, but slightly different. So they are allowing up to 25 units of housing to be exempt if located within a downtown, an ND, a neighborhood development area, or a growth center. And again, this is any type of housing, because they then should agree with our cap lifting. Yes, and so this does have a sunset though, so it's increased units of housing to trigger Act 250 in those 3 designated areas, and it's for 3 years.
And it takes 3 years to go through the local housing permit stage, as with the case of O'Brien Brothers in South Burlington. It means that this would take effect in time for
Well,
it to go under Act
Does
250.
anyone know if there's room to put 25 units of housing in most of our downtowns unless we put them in 10-story buildings?
The NDAs and the growth centers helps
yeah,
with that because they're rings around the downtown. So some downtowns
Does
do have that
anyone
capacity.
know how much housing we can put in that I mean,
No.
we're hearing the number 20,000 units of housing. And we've got 41 miles of designated area. All told, most of that area is already fairly well developed.
Mhm.
No?
So then there's,
no, I think it's mixed.
there's an additional piece about village centers that we'll get to.
Yeah.
And there's the municipal piece, which is more than the 41 square miles. And, there's still 10 units anywhere else, and there's duplexing by right. So I hear you, but we're balancing our committees to
Well,
consider.
my balancing right now
Mhm.
is that this is the biggest power grab I've seen from the local towns in a long time. And I'm not sure, I'm pretty sure I'm not gonna vote for the housing bill. Because we are requiring that towns, no matter what their character is, that they allow duplexes, quadruplexes. If I take my water and sewer out, we are telling them you must. And yet we are not willing to give up any of our control. And I've decided Senator White isn't here to speak, and I don't think any of you have served on planning commissions. But our children have grown up. They do planning and zoning. We are telling them how they must do it. but we are not willing to give up any of our control anywhere else, and I don't think it's fair. I just
started talking about the Act 250 sections. We're not gonna vote today. We're gonna
Yeah,
have
and
conversations over the weekend. It's it's fair to express.
And so I would
People
also
are, I
add,
just wanna get
this
through.
is fairly close to what you passed.
Right,
This is, you passed 25 units in any designated area. This is, so there are 5 of them. This is only in 3. And then their bill does address village centers additionally in the next
yeah, it
section.
expands, it does a ring around.
but to be fair to Senator Cummings, we had 25 by 5 by 5, so
Right.
in the 5 years, in 5 mile radius, you could go up to 25. We had a conversation in committee about people already in here having mixed feelings about that if there's no zoning. So they created this this designation that in village centers, that if they meet those, they can actually go up to 50 now.
Right.
So,
where can you put 50 units of housing in a village center?
well, you're not gonna do it all in one place, potentially. I mean,
Give me-
Stowe is a
Give
village
me a
center.
village center as an example.
Okay,
Where's a village?
So there's 200, so they range from smaller towns to pretty large
so
towns. that just
Woodstock,
have
I mean,
it.
Woodstock could absorb a lot of units.
Yeah, right.
Do you think Woodstock will
I think Woodstock would love to.
put in 50 units of affordable housing?
Absolutely, I would be.
That's not the
You know, we've
story
done
we
our
told
battle on
Grania
this. I think
before.
we're ready. Everyone's desperate.
So I anticipated that we might need to reschedule this for Tuesday. Anyway, so I think it's fair for it to elicit strong feelings. And that's why we're just sitting with it.
Yeah.
And
Understanding it fully. So
Yeah.
I want to finish
Right.
understanding it fully, but I think we have to get to go.
yeah, so thank you, Ellen.
So we will reread our bill and look at the changes in context of our bill.
Agonize over it over the weekend.
Yeah,
My goal is to not even think.
this was a very productive crossover day. Thank you, committee.
Well done.
Thank you.
Chair, we got lots of
Good job.
good bills.
Great.